everyone. Thank you so much for joining us for the very first YSIAC webinar on virtual mock hearing cross-examination. My name is Ma Suen. I'm the Business Development Manager Legal at SIAC, and I will be a moderator today. I'm extremely excited to be in this webinar alongside a group of up-and-coming as well as experienced arbitration practitioners. During this session, please feel free to send us your questions in the Q&A function at the bottom of your screen, and we will try our best to address your questions during the panel discussion later. Today's virtual mock hearing consists of 2 cross-examination sessions and a panel discussion later. This mock hearing is based on a hypothetical case scenario, and if you have your case materials with you now, please feel free to refer to them as we move along. I will first begin today by introducing the case scenario. The claimant in this case, Royal Istana Construction Corporation Iraq, RICCI, is a major land developer in Iraq. The claimant secured a tender for developing a nuclear power plant in Iraq. The tender required the claimant to complete construction and commissioning of the plant, latest by early February 2017. On 8 January 2016, the claimant entered into a contract with the respondent, Nucleus Energy Group, as contractors to construct the plant. The contract, however, did not provide a timetable for the completion. The claimant alleges that Nucleus Energy had assured them that the plant would be completed in 12 months from the date they signed the contract, which is 8 January 2016. The plant was, however, only completed and commissioned on 9 August 2017. As a result, and pursuant to an arbitration clause in the contract, the claimant commenced an SIAC arbitration against the respondent for 2 reliefs. First, damages of 6 million for the delay, and 2, a declaration that they were entitled to rescind the contract for misrepresentation. The respondent resisted the claim and in turn brought a counterclaim for some of the payments due under the contract. The respondent is also relying on clause 22.2 of the contract that excludes their liability for delays caused by subcontractors and delays relating to government regulations. The respondent denies that it had made any representations as to the timeline for completion. The respondent claims that it had always made it clear that any discussion of timeline was only indicative because the plant parts had to be significantly modified or refabricated in order to suit the site in Iraq. Witness statements and documents were exchanged pursuant to the procedural timetable laid down by the tribunal. And today, it speaks for the evidential hearing for cross-examination of 2 factual witnesses from each party. Now, before we begin the cross-examination sessions, let me first introduce you to our speakers and the roles that they will be playing. The tribunal today consists of Mr. Darius Chan of Fountain Court Chambers. Hi, Darius.
Good afternoon, everyone. Hi, everyone.
Then we have Ms.
Hello.
Blossom Heng of Drew and Napier.
Hi, everyone.
And Mr.
Hello.
Yutaro Kawabata of Nishimura and Asahi.
Good afternoon.
Hi.
Blossom will be the presiding arbitrator today. For the first session of cross-examination of the claimant's factual witnesses, the first counsel for the respondent is Mr. Lomesh Kiran Nidumuri of Indus Law. Hi, Lomesh.
Hello.
Lomesh will be cross-examining the claimant's first witness, Mike Ross, who is Mr. Eddie Lee of FTI Consulting.
Hello, everyone.
The second counsel for the respondent is Ms. Lee Chun Chui of Clifford Chance.
Hi,
Hi, Lee
everyone.
Chun. Lee Chun will be cross-examining the claimant's second witness, Taufik Tariq, who is Mr. Benson Lim of Hogan Lovers.
Hi.
For the second session, it will be a cross-examination of the respondent's factual witnesses. The first counsel for the claimant is Mr. Jonathan Lim of Wilmer Cutler Pickering Hale and Dorr.
Hi, everybody.
Hi, Johnny. Johnny will be cross-examining the respondent's first witness, Harvey Specter, who is Mr. Jared Leong of Herbert Smith Freehills. The second counsel for the claimant is Ms. Sharon Chong of Screen.
Hi, everyone.
Sharon will be cross-examining the respondent's second witness, Frankie Talor, who is Mr. Dimitris Katsikis of Sherman and Sterling.
Hello from me as well.
For your reference, everyone, the speakers' names and their roles are all on the screen. Without further ado, we will now begin the first session of the cross-examination. Thank you.
Members of the tribunal, I represent the respondent in these proceedings, and I'm here to cross-examine Mr. Mike Ross. My co-counsel is Ms. Lijun, and she'll be cross-examining the other witness. Good evening, Mr. Mike Ross. I hope I'm loud and clear to you.
Hi, good afternoon. Hearing you loud and clear.
Excellent, thank you. Mr. Mike Ross, in para 3 of your affidavit, you have mentioned that you were involved in several construction projects earlier. So would it be correct to say that as the director of operations of Royal Istana, that you were involved in several projects in which you engaged the services of various contractors?
That's right. So Royal Istana is a construction company specializing in large projects in the Middle East. I've been with the company for many years now, eight years in total. And during that time, I worked on many projects that the company was involved in. They typically relate to building hospitals or schools or roads of that nature. But you're right, I have overseen a number of those projects in my time with the company.
Great, excellent. Thank you very much. Mr. Mike Ross, would it also be correct to say that the requirements for each project that you have undertaken as the Director of Operations of Royal Istana would vary typically from project to project, because that will be based on different site conditions? Would you not agree with that?
I think it's more general than that. I think each project has its own challenges, each has its own timelines. And depending on the nature of the project, obviously there'll be different timelines, different challenges. I think the key for us is to make sure that we have the right contractors and subcontractors in place to be able to deliver the projects on time, on budget, and to the correct safety requirements.
Right, thank you very much. Mr. Mike Ross, would you agree that the project that had to be ultimately commissioned and constructed in Iraq had to be in consonance with the tender conditions that would have been issued by the government of Iraq?
So yes, we had a contract with the government in Iraq to deliver the nuclear power plants at a certain date.
Right.
And obviously we tried our best to adhere to those contracts, as we do with all the contracts that we have here.
Thank you. So would you agree, Mr. Mike Ross, that the tender conditions that would have been issued by the government of Iraq for building a nuclear reactor at Iraq need not be the same specifications as a nuclear reactor that could be in any other part of the world? In other words, no two nuclear reactors in that sense, the technical specifications could be the same.
So I think obviously the technical requirements are something that I do not have specific expertise in, but what I understand from the contract itself is that there were a set of requirements given as to the specifications of the power plant in Iraq in terms of capacity and so forth. What I can say is that we obviously contracted Nucleus Energy to build the plant according to those specifications.
Mr. Mike Ross, I draw your attention to Exhibit A. Could you please look at page 13 of the compilation?
Give me one second.
Well, no problem.
I have that, yes.
Yes. Could you please confirm that the emails which are on the top two, right at the top of the page, and I count right at the top of the page as a first mail, and the mail right below that is a second mail. Could you confirm that these are emails that have been sent by you?
So the first email was sent by Mr. Spector.
That's right.
And the second email is the one that I sent to Mr. Spector in January, just prior to the meeting.
That's right. Thank you for clarifying.
The confirmation that the plant's parts was ready to ship to Iraq for the project.
Thank you. Was there any meeting that took place on January 5th, 2016 on a Tuesday between the parties?
There was a meeting in London in early January that was attended by Mr. Tariq from Royal Astana, and I believe he met with various people from Nucleus Energy.
So Mike Ross, I'm sorry, I don't think I have got the answer to my question. If I may please repeat it. My question is, what took place on Jan 5th, 2006? Clarify that further, or did the meeting end Friday when the contract was signed?
I believe there was only one meeting on one day in London, and that was on the Friday when the contract was concluded. I
draw your attention, Mr. Mike Ross, to the second email at page 13 of Exhibit A. You have said, "Dear Mr. Spector, please could you ensure that you provide at or prior to the meeting taking place in London next Tuesday?" So that is January 5th, 2016.
Yes, I see that.
So do you still stand by your statement that you just made, that this meeting took place only on Jan 8th?
Yeah. Yes, I mean, there was only one meeting and I wasn't in attendance. To the extent that there's a difference between a Tuesday and a Friday, I must have got my dates and days of the week mixed up, but there was only one meeting.
Mr. Mike Ross, please also look at the email which is right on top of the same page. This appears to be an email sent by Harvey Spector to Mike Ross on Jan 3rd, 2016, about 12 minutes after your mail was sent. And the mail curiously reads, "Dear Mr. Ross, please see below for your attention." So my question to you, Mr. Ross, is, according to you, were the documents listed in your second email, that is the engineering drawings for the proposed nuclear plant and the photographs of the reactor, were they enclosed to the email that is on top, that is January 3rd, 2016, 1851, addressed by Harvey Spector to you? Were those documents forwarded to you?
No, I hadn't, up to that point, I hadn't received the drawings or the photos. I think when Mr. Spector says, "Please see below for your attention," I believe he was just referring to my email below. And there was no attachments attached to the emails.
Mr. Mike Ross, don't you think it's a bit odd that Mr. Harvey Spector sends a response to your own email and he says, "Dear Mr. Ross, please see below for your attention"?
I didn't read it in that way.
I would want the learned arbitral tribunal members also to note, and this is the contention that we would be taking, that they are disputing the emails which are at page 13, the top two emails, because there was firstly no meeting on Tuesday, Jan 5th, 2016, that was January 8th. And there were, according to the witness, there were no photographs which were enclosed to the above email. So it raises suspicion on the authenticity of the mails itself. Thank you very much, Mr. Ross. Moving on. In your witness statement, could you please see your witness statement, Mr. Mike Ross? I draw your attention to para 8 of your witness statement. Could you please have a look at that?
Yes, I have that.
Yes, Mr. Mycross, could you please look at the last two lines of this paragraph in which you said, you refer to an email on 3rd January 2016, and then you say there were subsequently no further communications between myself and Nucleus Energy. So when you refer to your email in para 8, you are referring to, may I please draw your attention to page number 13 of the compilation, please? You have referred to the second email, which is listed at page 13. There is an email sent by you on Jan 3rd at 1839. And you said furtherance of this particular email of January 3rd, 2016 at 1839, there were no subsequent emails or communication. There was no further communication between myself and Nucleus Energy. In the light of the fact that you yourself have, there is an email which is produced with Jan 3rd, 2016, 1651, which is right on top. Would you still stand by the statement that you have made in para 8 of your affidavit? There were no further communications, Mr. Mycross?
I do. I think what I meant by no further communications from me to Mr. Spector on this issue. I mean, obviously, I received a response from Mr. Spector to my email on the 3rd, and there was no further correspondence or emails since then.
Thank you, Mr. Ross. Mr. Ross, would you also agree that after the email, if you please have page 13 of the compilation, after the email dated 18th October 2015, which was issued by Mr. Harvey Spector to Mr. Mycross, that's you, and Mr. Tawfiq Tariq, is it correct that there were no subsequent attempts made by you to reach out to the officials of Nucleus Energy, calling upon them to give you a specific undertaking in writing that the project would be completed within a specified timeline?
Well, I didn't think that it was necessary to get that specific undertaking because Mr. Spector already confirmed to me over the phone that they were able to deliver the project on time and by January 2017 by using the parts that were diverted from the Indonesian power plant to Iraq. And as you can see from the correspondence between Mr. Spector and I, if you look at the subject title, it already said plant parts readied in Texas. So from that, I assume that the parts were ready to be shipped and ready to send to Iraq to start the project.
Right, thank you. At the time of entering into the contract on 8th of Jan, did you or any other official of Royal Astana insist on an inclusion into the contract about the definitive timeline being 1 year from the date of the contract?
So I can only talk from my perspective. What I got was the verbal assurances over the phone as to what Nucleus Energy can deliver, and they were very firm about being able to meet the deadline of January 2017. All their actions seem to indicate that they were able to do that. They were a reputable company. They were obviously charging a premium for their service, which we were willing to pay to get the project completed on time. I understand Mr. Tariq was in London to negotiate the contract. I say I wasn't part of that meeting, so I can't comment on the specific inclusion and exclusion of specific clauses.
Right. Thank you, Mr. Ross. So, Mr. Ross, could you also confirm that there was absolutely nothing in writing that was issued by Nucleus Energy confirming to you or any other official in Royal Astana that the definitive timeline would be 1 year from the date of execution of the contract?
I believe if you look at Exhibit A, the email on October 18th, the Sunday.
Right.
As a bit of context, I was pushing Mr. Spector, obviously, to give that definitive timeline, that definitive commitment. You can see from my previous email as to my thoughts on that, and I thought it was important, obviously, to get a commitment from the company to have the plant ready by January 17. Mr. Spector in his email suggests that we can divert the plants to Iraq and meet my demands. Subsequent to my email, I spoke with Mr. Spector, and that's where he confirmed to me over the phone that they were ready to deliver to those timescales.
So, Mr. Mycross, so can I take it that other than the emails that you have produced, which finds a mention at Exhibit A and Exhibit B, there are absolutely no other communications that have been exchanged between the parties in which there is any indication of my client giving a definitive commitment of 1 year from the date of execution of the contract?
I don't think there's anything else in
Thank you.
In evidence.
Mr. Mycross, at any given point of time, did you or any other official in Royal Astana ask nucleus energy officials as to what are the technical specifications of the nuclear reactor that was built in Indonesia?
I obviously discussed when Mr. Spector raised the possibility of diverting the plant's parts from the Indonesian project. Then we obviously discussed that. I'm not sure what you mean by technical specifications, but given that Mr. Spector said that the parts can be diverted, I took his word that that those were to be used in the project in Iraq.
So let me make my question a little more clearer, Mr. Mycross. So my question really was, did you check, when I meant the technical specifications, I meant the engineering drawings and designs for building a nuclear factory in Indonesia. Did you call upon Nucleus Energy to provide you with the details of those? Because only upon an examination of those details would you know whether the materials that are lodged or already erected in the Indonesian factory are fit for use in Iraq. Did you make that assessment at all?
So if you cross-refer to my email, Exhibit A, those were the technical drawings for something that I asked as part of the January meeting, along with the photos. Understand, obviously, that I thought those were important to understand what parts were ready, and try to get a sense of whether those parts could be shipped immediately to Iraq. This is something I mentioned to Tarek over the phone prior to his meeting in London. I understand that in his witness statement, he said that he was giving the photos and the drawings, which he looked over. So those were sort of important consideration for myself, but I was never provided with those documents prior to signing the contract. It was only Mr. Tarek that had access to those. But I made Mr. Tarek fully aware of the importance of those documents.
Mr. Mycross, when was the first time that either you or any other official in Royal Astana asked for photographs of the parts that are already lying in Indonesia or Texas?
I think these are something that I've been speaking with Mr. Spector throughout our negotiations. I think in writing, it will be in the January emails.
So would it be correct to say that from the period when you were awarded the contract by the government of Iraq in April 2015 till January 2016, you did not think it was important to ask for photographs that were lying of the nuclear power plants that were lying in Texas? And the pain point really was that of pricing issue as per your own affidavit.
So I think slightly well, we were awarded the contract in April. Obviously, it takes some time to understand the specifications that were required to be built, and obviously we looked at other third-party contractors to see whether they can build the power plant in time. It was only in late October that Mr. Spector raised the possibility of diverting the parts from Indonesia, and it's at that point that we followed up. So as soon as Mr. Spector raised that possibility in October, we were following up from that point onwards.
Mr. Mike Ross, I asked this question specifically to you because you are the director of operations of the claimant, and you've worked in the organization for 7 years, so you have rich field experience also in that sense. In all the projects that you have executed, I mean, let's forget about this particular project, the earlier projects that you have executed, would you agree that the nature of the components, the engineering designs and drawings would all vary and differ based on the topography of the respective site?
I think it would depend on the construction project. I'm not a technical expert on construction. I rely on contractors and subcontractors to be able to recommend solutions that fit our requirements. And I set out my requirements very clearly to Royal Istana, and I was assured that those requirements would be met.
Right. Was there any person within Royal Istana who was entrusted with the task of checking and verifying the engineering drawings and the photographs that were submitted? And if so, who was it? I'm sorry. If so, who was it?
I think by the nature of the delay in getting the responses from Nucleus Energy, it was up to Mr. Tariq to obviously review the plans and review the photos in his meeting in London.
Have you seen those photographs, Mr. Mike Ross?
I have not seen the photographs.
Did you ask for the photographs at any given point of time?
I obviously asked Mr. Spector for the photos before the meeting in London. After the contract was signed, then no, I didn't think it's worth pursuing asking for those photos. I assume the parts will be ready based on Spector's representations, but also Mr. Tariq's review of the photos and plans.
All right, thank you very much, Mr. Mike Ross. I think my time's up, so thank you very much for your time. With the permission of the learned tribunal members, I will not be posing any suggestions to the witness. I think my co-counsel Lijun can take it up with the other witness. Thank you very much.
Thank you.
Thank you.
Before the next witness come on, before the counsel for the second, who is going to cross-examine the second witness proceed, what we'd like to do is to affirm the witness. So, Mr. Taufik Tariq, you see a document before you that has your name on it?
That's right. That's my witness statement.
Thank you. Would you confirm for the tribunal that the evidence you will be giving today in this arbitration shall be the truth?
Yes, that's correct.
Thank you. Ms. Tree?
Thank you, Madam Arbitrator. Now, Mr. Tariq, due to the limited time that we have today, you should simply answer yes or no to my questions, which are designed that way. And if necessary, you will be invited to further explain your answers. My first question to you, we are here today because Royal Istana claims that Nucleus Energy promised to complete the nuclear plant by January 2017.
Yeah, that's right. I mean, they did promise to keep it by 8 Jan 2017.
And it is your evidence that Nucleus Energy told you that they had prefabricated parts that could be used to build the plant in Iraq?
Well, they didn't tell me specifically, but as you can see from the emails that I was copied in, specifically, I can point to the emails that we sent to them before the January meeting. If I remember correctly, I think sometime around 3rd of Jan. That was what my colleague Mike sent. I was copied in that. So it was important for us that the parts that were referred to was the parts in Texas.
So you are saying that by the 3rd of Jan email, Nucleus Energy told you that the prefabricated parts could be used to build the plant in Iraq?
We had to assume. In fact, actually, we actually were.
Sorry, are you saying that it's based on the 3rd of January email?
On top of many things, I mean, we didn't write it down. I know I agree that our contract could have been clearer, and I admit that it could have been clearer.
We have not gotten there yet. Thank you, Mr. Tariq. So let us just take it one step at a time. Was this Royal Istana's first nuclear power plant?
I think so. I can't remember because I think when we took over in 2013, that's when we tried to transit.
Do you have any prior experience with construction of nuclear power plants?
No, I was involved in petroleum. I was with Petronas and I was doing oil and gas in the Middle East. I was not involved in nuclear plants.
Thank you. So your answer is no. Now, was the contract in question made at a meeting in London on 8th of January 2016?
That's right.
And that was a Friday?
That's right.
Now, just about the meeting, were you the sole representative of Royal Istana who attended the meeting?
That's right.
And you decided that Mr. Mike Ross should not attend?
No, I didn't decide. I mean, it was just like, it wasn't waste. I mean, we as Royal Istana, we don't like to waste money. So, I mean, I'm the CEO, so clearly I'm entitled to turn up and make decisions.
Now, Mr. Ross, in paragraph 8 of his statement, I'll just read it to you. He says, Mr. Spector ended up proposing that the parties meet in person to thresh out the differences between them. I was not keen on this as I felt that more problems were likely to emerge, even if we managed to agree a contract. Unfortunately, I was overruled by Mr. Tariq. Would you agree with what Mr. Ross has said in his witness statement?
Yeah, he said that he didn't want to go, so I'm fine. I will turn up because I do want to close the contract.
Mr. Tariq, that's not what he said. And what I just read out to you was that he didn't think the meeting should proceed, but you decided that it should.
Yeah, so you see my level 4, paragraph 4 of my witness statement, I said the same thing. I said that he didn't think it was good to proceed, but I thought I can attend without him.
Okay, thank you. So you decided to attend the meeting alone and you managed to complete the negotiations alone?
That's right.
Did the negotiations take long?
It took enough time. I mean, it was just before dinner. We tried our best to thresh out. I mean, we tried to work out the details as much.
Would you say it was a long discussion?
I can't remember, honestly. It's been almost 4 years. I think it was, it's tiring at least. I do remember, however, that I took a lot of time to make sure that the photos that was given were in fact labeled properly.
Thank you. So to refresh your memory, by your very own witness statement, you said that it was a long and difficult discussion. So let me just leave it there. You say in your witness statement that there was a long and difficult discussion. You felt that you were able to complete the negotiations yourself. Yeah. Did you manage to conclude the negotiation?
Yeah, I mean, we agreed on the price. I mean, that price was a big stickler. And was
it a final contract that you agreed on?
Yeah, it was a contract that we agreed upon. But I mean, I just want to be very clear. It could have been dropped.
Yes or no?
It was the terms of it. I mean, like I said, I mean, there were some terms that had to be, was understood by both parties.
Was it signed by both parties?
It was signed by both parties.
Now, you have drawn the distinction between what was understood and what's in the contract itself that was signed by the parties.
Yes.
In the contract that was signed by the parties, did it contain a deadline for completion?
No, it didn't. I thought it was understood. I mean, we were negotiating for almost a year. Come on. I mean, it has to be understood.
Okay, we can talk about your so-called understanding later. Now, let's talk about what the contract did in fact contain. It did not contain a deadline, but it contained a clause 22.2, which says that Nucleus Energy is not liable for a subcontractor's delay. Is that correct?
That's right.
Now, Mr. Tariq, we've heard about how you traveled all the way to London to negotiate the contract.
Yes.
It was a long and difficult discussion.
Yes.
And by the end of it, you decided that it's not necessary to record it in the final contract that completion should be January 2017.
No, I mean, we both forgot. I mean, it's not just me, but clearly the respondent forgot as well. I mean, the CEO didn't remember either. We have important things to dismiss. Yeah, I mean, we understood. It wasn't a matter of contention. I mean, they knew that we had a deadline. They knew we had a deadline.
Thank you, Mr. Tariq. Now, for the contract that Royal Istana had with the government of Iraq,
Yes.
Royal Istana was required contractually in the signed contract to deliver by January 2017.
Yes, that's right.
And this was not in the signed contract between Royal Istana and Nucleus Energy.
It's not expressly written. Yes, you're right.
Okay, I put it to you that the contract did not contain the deadline because there was in fact no representation by Nucleus Energy that the plant would be completed by January 2017. Do you agree?
I disagree. I mean, this was actually written in the emails that we had changed with them in October 2015.
Okay, noted. We'll get to that in a while. Now, we talked about how Mr. Ross did not attend the meeting, but did he prepare you for it?
We had discussions. I mean, I got more involved in this in November 2015, where the discussions on price became more protracted.
Okay, your answer is noted. So did Mr. Ross, when he was preparing you, relay all the important negotiation points to you?
We discussed the most important points, like for example, the fact that I had to check the parts, using photographic evidence. And you saw that the emails that you were talking about, we wanted to see the photographs of the parts.
Now, just to make sure I get you correctly, you discussed the most important points.
Yes, that's right.
Okay, thank you. Now, in his statement, specifically paragraph 9 of his statement, Mr. Ross describes how he prepared you for the meeting. He says, I rang Mr. Tariq on his mobile phone on Monday evening to ensure that he was aware of the importance of the photographs we had asked for. He assured me that he understood, and I did not hear further from him until after the conclusion of the meeting, which took place the following day. Do you agree with what he said?
If I remember correctly, I think that was probably right. I think I only raised it again on the photographs in my email to Harvey on the Monday after the meeting.
Okay, your answer is noted. So now, in your statement, you also talked about how Mr. Ross prepared you for the meeting.
Yes.
In paragraph 6, you said, Mr. Ross had told me in a telephone conversation earlier that morning that these were important. We needed to be sure that Nucleus Energy did in fact have certain major nuclear plant components.
Yes.
Do you then stand by your statement?
Yeah, I mean, it was 2 a.m. I mean, I'm a workaholic, so I mean, the date's roughly around there. Yeah.
Okay, noted. Now, Mr. Ross has said that he talked to you on Monday evening, but in your witness statement, you said that he talked to you earlier that Friday morning. It's either Monday evening or Friday morning. So which is
I think me and Mike, we talk regularly. So clearly I can't remember exactly which conversations. Like I said, it's 4 months. It's quite long ago. But I know there were constant discussion because we're keen to get this project over the line.
Now, the thing is, Mr. Ross in his statement also said, I did not hear further from him until after the conclusion of the meeting. So according to Mr. Ross's evidence, he only spoke to you once on Monday evening. So again, who is correct, you or Mr. Ross?
I think the point is that we were discussing the same thing. I don't know whether how many conversations we had. I can't remember exactly, to be honest, but I would say that we discussed it. I don't think that whatever discussions we had changed from what we wanted from the other side.
Okay, noted. So there's a contradiction in when you actually spoke. Now, I want to ask you a few questions about what happened during the 8th of January meeting.
Okay.
In your witness statement, you discussed that as well. And perhaps just to refresh your memory, I'll just read parts of it to you.
Yeah.
You said, before the meeting started, Mr. Spector handed me a large envelope, which he said contained some pictures of nuclear plant parts and components, which Mr. Ross had asked for previously.
Yes.
You also say, I specifically recall that Mr. Spector left the meeting room after he handed over the envelope to me, saying that he needed to grab a file from his office, whereas Mr. Telor was speaking on his mobile phone in a corner of the meeting room.
Yes.
After Mr. Spector returned to the room, Mr. Telor ended his call, and I placed the certificates and photographs back into the envelope.
Yes.
We started our meeting shortly thereafter, and after what seemed like a long and difficult conversation, we ended up reaching an agreement on the terms of the contract.
Yes.
Do you confirm everything that was said there?
Yeah, that's correct.
Now, according to what I just read out to you, Mr. Spector only told you that they were pictures of nuclear plant parts and components.
No, he told us the photos that were from last week. If you look at the email, we had a discussion, if you refer. There were specific photographs, and it was exactly like I said, the 4 items. cooling towers, pumps, generators, and reactor. There were 4 things, and it was stated in the email, and that was what I was interested to look for.
Mr. Tariq, focusing on what happened during the meeting itself and what Mr. Spector told you. According to your witness statement, he only told you that they were photos of the nuclear power plant parts. He did not say anything else. Is that correct?
No, he said that those were the photographs that Mike had asked for previously, and those Mike had asked for previously were the 4 items. I mean, that was what Ross was asking, Mike was asking for, and so I cannot understand. I mean, that makes sense. He was giving me what Mike was asking for.
So your evidence is that he gave you the photos, which was what Mike was asking for.
That's right.
All.
That's paragraph 5.
He did not say anything. He did not say anything else.
Yeah, I can't remember. I don't think he did.
Okay. Now, do you agree that it is common industry knowledge that nuclear power plants parts are never ready to ship immediately and will always need to be modified or refabricated?
I assume there will be some work that's required, yes.
Just to note that you said that you assume that there'll be some work that's required.
Yes, because that's why we engage a very expert like them. You know, we are not expert. Like myself, I've spent 25 years in petrol engineering. I'm not a nuclear plant, so I would assume there was some work that will be required. Yes.
Okay. Now, can I take you to Exhibit A at page 13 of the bundle in front of you?
Mm-hmm.
Now, you will see that there's an email dated 3rd of January, 2016 from Mr. Mike Ross, and I believe that you have made reference to that email as well.
That's right.
Now, there's a response from Mr. Harvey Spector.
Yes.
You are not copied on that email.
No, I'm not.
Now, in his email, Mr. Harvey Spector says, please see below for your attention. Do you think it's possible then that Mr. Ross had received the photos via the email of 3rd January at 6:51 p.m.?
Look, I'm just speculating, and I wouldn't know. All I know is that I got a hard copy on that meeting on Friday.
Sure, but is it possible that Mr. Ross, your colleague, also received it via email?
Look, I really do not know.
Okay. Now, further down.
I'm sorry that our time is up. We will need to move to the next round.
Sure. Thank you for your time, Mr. Tariq.
Thank you.
Thank you, Mr. Tariq.
Thank you.
Can we have the respondents' first factual witness up, please? As well as the counsel, Johnny. Right.
Good afternoon.
We won't need to affirm the witness again, we'll just proceed.
Thank you, Madam Arbitrator. Good afternoon, Mr. Spector.
Good afternoon.
My name is Mr. Lim, and I'm counsel for the claimant along with Ms. Sharon Chong. I will be asking you some questions today. Before we begin, could you confirm that there's no one else in the room with you?
Yeah, I don't think so. You get fined very heavily if you have someone else in your house.
It looks blank to me. Could you confirm that you have with you the 4 witness statements in this case, along with exhibits A, B, and C?
Yes, I think I've been provided them. Would you like me to have them with me on the screen?
Yes. Not on the screen, just have them in front of you, and just confirm that you have nothing else in front of you, please.
Nothing else, yes.
Mr. Spector, you are the Director of Business Development of Nucleus Energy.
Yes.
You have been in this position since 2007?
Yes, I have been.
So you've been Director of Business Development for 13 years?
Yes, thereabouts. Time really flies.
And you joined Nucleus Energy in 1999, so you've been with the company for about 21 years.
Yes, that's right.
And Nucleus Energy is a leading manufacturer of power plants, nuclear power plants specifically.
We would like to believe so, yes.
And so it's safe to say you've had over 20 years of experience working on nuclear power projects with one of the best manufacturers in the market.
Yes, that will be a good summary.
And Mr. Frankie Taylor, your CEO, put you in charge of the negotiations on this project because of your experience, isn't that right?
Yes, among other projects.
Thank you. Negotiations on this project started in July 2015.
Well, the first contact I got from the other side was in July 2015.
That was a call from Mr. Mike Ross.
Yes.
And negotiations continued, but they reached a deadlock around October 2015, correct?
Yes.
If you can turn to paragraph 6 of your witness statement.
I'm with you.
Negotiations reached a deadlock because neither party was willing to back down from their key demands, correct?
Yes, there were some roadblocks at that point.
And one of these key demands was the price to be paid, correct?
Yes, we wanted, I think at that time we wanted a higher price than RCCI was willing to pay.
That's right. And Royal Astana thought your premiums were excessive.
Yes.
Correct? Well,
As
you thought it was
any good buyer.
Yes, of course. And you thought that these premiums were justified because you were the best or one of the best manufacturers in the market, wasn't that right?
Yes, we certainly thought so, as with any good seller.
And if you look at paragraph 5 of your witness statement, you say that only a company of your caliber and reputation would be capable of meeting Royal Istana's requirements for completing a project by January 2017. Do you see that? Mr. Spector? I believe we might have lost Mr. Spector temporarily. Can I just check that I can still be heard?
We can hear you, counsel.
Thank you, Tribunal. It seems that we have a technical issue.
Mr. Spector, can you hear us? Doesn't seem like it. No, he's gone off, I think.
Shall we move to, why don't we park this for a while and we move to the next witness?
That sounds good.
Okay. Thank you, Madam Presiding Arbitrator. Good afternoon, Mr. Frankie Taylor. My name is Sharon Chong, and I'm counsel for the claimant. I see that you have prepared a 2-page witness statement. I will be asking you some questions on your witness statements. My questions are designed for yes and no answers, so I would appreciate if you could keep your answers short. If you would like to explain, you could do so later. As we are conducting this session virtually, there may be some intermittent connection problems, so please let me know if you need me to repeat my questions. Thank you. Okay, Mr. Taylor, you are the CEO of Nucleus Energy Group.
Yes, that's correct.
And you've been the CEO since 2007, and before that, you were the CEO of another nuclear plant manufacturer. Yes. And you have extensive experience in the manufacturing of nuclear plant. Is that correct?
Well, I'd like to think so. I mean, I have some experience, considerable, I'd say, yes.
Okay, thank you. And Mr. Taylor, you work closely with Mr. Harvey Spector?
Yes, that's correct.
And Mr. Spector is the Director of Business Development of Nucleus Energy Group. Am I right?
Yes, you are.
As the Director of Business Development, does Mr. Spector report to you on his projects?
Inter alia, I mean, you know, maybe to the board sometimes, or to, you know, if there's a financial issue to the CFO, but of course to me as well.
In this in this particular project with RICCI? Did he report to you?
I wouldn't use the word report. He definitely came to me at some point when he was first contacted, and I thought it was a good idea to put him in negotiations. And I think he came to me again when negotiations were reaching a sort of sticking point. So I don't think it was a kind of day in, day out reporting, if that's what.
Right, thank you. In your witness statement, at paragraph 2, you said that you had entrusted responsibility for the negotiations in terms of the contract with RICCI to Mr. Spector, and that he has had a good track record with several other nuclear plant construction projects, and that you were so happy to trust him with handling the negotiation process, yes?
Yes.
Yes. So you left it entirely to Mr. Spector to negotiate with RICCI, am I right?
No, I don't think that's right. As I said, he did the negotiations up to a certain point, and when we reached that sticking point, he had a great idea of having an in-person meeting in London, but then of course I was involved in the negotiations as well.
So up to the point where you had the meeting in London, was Mr. Spector negotiating with RICCI by himself?
Yes, I don't know if anyone else was involved in the team, but predominantly him for sure. Yeah.
Predominantly, and you were not negotiating directly with RICCI at the time.
No, I was not. No.
Thank you. And Mr. Spector will update you on the progress of negotiations. Well, he did at least at one time when he said that he told you that RICCI needed the plant. In your witness statement at paragraph 3, you said that Mr. Spector told you that RICCI needed the plant within a short time span, and in any event, no later than January to February 2017. Do you confirm that?
He did say that, but of course, you know, what RICCI needed to what we told RICCI are two very different things, right?
Yes, but he told you that that was what he understood and that was what you were updated on. Yes.
Yeah, we were aware of RICCI's requirements, but yeah, as I said.
Thank you. So you knew then at that time, at least when Mr. Spector was updating you, that the plan had to be completed and up and running by January 2017.
No, that I don't agree with that statement. We knew that that's what RICCI wanted, not that it had to be completed up until January 2017. These are two different things. Right.
Can I refer you to paragraph 3 of your statement, Mr. Delore? Here I read, Mr. Spector mentioned to me that RICCI had approached him regarding constructing a nuclear plant, which they needed within a short time span, and in any event, no later than January to February 2017. So here you said you knew, or Mr. Spector had told you that RICCI needed the plant no later than January to February 2017. Do you stand by your statement, Mr. Delore?
Yeah, absolutely, yes.
Thank you. And in the same paragraph of your statement, you then mentioned to Mr. Spector that you could always divert a plant or its components from one of your other projects to Iraq if need be. Yes?
Yes.
Okay. And you also said that that would save a lot of engineering time and manpower. Yes?
Yeah, I mean, if we can do it, you know, technically, if it's possible, it does save time, yeah.
Right. And did Mr. Spector agree with you on this at that time?
I think so. Yeah, I think so. I think I also say that in paragraph 3. I think so.
Right. Okay. Thank you. Do you know? Well, even by October 2015, you had not finalized and concluded the contract. Am I right?
Right.
Yes. And do you know the reason why negotiations became protracted? Was it because of the pricing issues?
I mean, as I said, I think it was mainly the pricing issue, but maybe Harvey is more to speak to on this since he was carrying out negotiations. But I think chiefly the pricing issue, probably, yeah.
Thank you, Mr. Delore. And by pricing issue, you mean that that Nucleus Energy wanted to impose price premiums on RICCI. Yes.
Well, I think, you know, we consider that we give a premium service, so we charge for it. But I don't, you know, I think that's the case regardless of the timeline. You know, if we think we give a better service, we charge a higher price.
So Mr. Spector said in his statement that he felt that the price premiums were justified given Nucleus Energy's status as the market leader in the field, and also as the only company of caliber and reputation that is capable of meeting RICCI's requirements for completing the project by January 2017. Do you agree with him?
Yeah, I do. I'd put the emphasis on that statement on capable. You know, a company like Nucleus is one of the few players in the market that can do it under certain circumstances. But you know, I think that's quite different to saying that we promised to do it or we held out ourselves as agreeing to do it.
Okay. And when was the contract finally signed?
Oh, I think it was signed on the spot in January 2016, if I'm not mistaken.
And that would be at the meeting, after the meeting on 8th January 2016.
Yeah, in situ, yeah.
Okay, thank you. In your witness statement, Mr. Talor, paragraph 5, you said that you managed to reach an agreement on most of the terms of the contract fairly rapidly, and you managed to sign the contract at the end of the meeting. Would you agree with me that parties had finally agreed then on the terms, including the key issue of price premiums?
Well, yeah, on the price we agreed, but that's, you know, that was a big win for us. Yeah.
And you yourself stated in your witness statement were surprised that it was agreed to so quickly.
Sorry, would you mind repeating that?
Sorry, in your witness statement, you stated that you yourself were surprised that it was agreed to so quickly. The terms were concluded so quickly.
Well, yes, considering that, you know, the negotiations had been drawn out for so long, I think it was good to get Mr. Tariq in person, because that's what really helped, you know, negotiations to be concluded. Yeah.
Yeah, and it sounds to me that the parties did not even need to go into the nitty-gritty details, and you left the meeting happy and satisfied that you were clear with all the terms. Yes?
No, I don't. I think that's oversimplifying things a little bit, if you don't mind me saying. We sat down and we had a productive meeting that lasted at least an hour and a half or something like that. And then we actually produced the contract on the spot. So I think there was plenty of time and plenty of discussion for RICCI to raise, you know, any key issues that they had, any problems that they had, which they didn't. Mr. Tariq did. So we were happy to conclude the contract, but yeah.
Thank you, Mr. Delora. During the meeting, was there any discussion on the timeline for the contract?
No.
And during the meeting, did you say, did you or Mr. Harvey say that you could not deliver by January 2017?
Well, no, but we never said we would commit to delivering. So
there was no discussion on the timeline, and you did not say that you could not deliver by 2017. Your answer appears to be that you agree with me.
I agree that we never said we could not, but I'd also supplement that by saying we never promised we would.
Okay, there was no mention of that. Okay, thank you, Mr. Talor. During the meeting,
Thank you. Time's up for this witness, and it appears we have Mr. Spector back.
Okay, thank you. Thank you, Mr. Talor, for your time.
Thank you. There you are. Welcome back, Mr. Spector.
Thank you. I do apologize tremendously for dropping off the connection issues. We're not as good as routers as we are with nuclear. Thank you. I do apologize, Mr. Lim.
We won't impute anything to the timing of your disconnection.
I once was told that if you come under heavy fire and cross-examination, you should try and drop out.
Shall we proceed? I think we were talking about the price premium that you were charging. And we were talking about how you were the best nuclear plant manufacturer in the market.
Yes, yeah.
And I was taking you to paragraph 5 of your witness statement, where you said only a company of your caliber and reputation would be capable of meeting Royal Istana's requirements for completing a project by January 2017. Do you see that?
Yes, I think we certainly, yeah, I see that.
You believe that this justified your premium, didn't you?
I think at that point in October, when we didn't want to reduce our price, we did believe that, given the competition available, only a very small, very, very small field of people could offer, could do the project as speedily as we could. So we therefore felt that it was worth paying the price that we had quoted.
Understood. So you could do it faster than other manufacturers, correct?
Yes, most likely.
When Mr. Ross called you in July 2015, he told you that Royal Istana needed help with constructing a nuclear plant in a short time span?
Yes, I mean a fairly short time span.
Yeah, well, if you look at paragraph 3 of your witness statement, you just say short time span there. And he said, in fact, that this had to be up and running by January 2017.
Thereabouts,
yes. Is that correct? And after your call with Mr. Ross, you discussed this project with your CEO, Mr. Taylor?
Yeah, we had a brief discussion because I got a cold call, and he said, yeah, go with it and take it as far as you can.
If you look at paragraph 3 of his witness statement, yes. He says you told him about the project with Royal Istana, and that you told him that they needed a nuclear plant no later than January to February 2017, correct?
Yes, I told him that Mr. Ross mentioned the January 2017 time frame that he was hoping to achieve.
So you were both aware of the timeline that Royal Istana needed the plant to be up and running, which is by no later than February 2017, correct?
I think when Mr. Ross, what he told me was that ideally he liked it by January 2017, and I conveyed the same to my CEO. Obviously, at that stage, it was the first call. Sorry.
Of course, sorry to interrupt, but Mr. Taylor does say something different. He says that you told him they needed the plant by no later than February 2017. Do you agree with his description of your conversation?
Well, it was probably a brief conversation along the corridors of the office, so I don't really know the exact verbatim words that were used. But I just indicated that, in terms of time frame that they had in mind, it will be January 2017, thereabouts.
And this timetable was one of the other key demands of Royal Istana during the negotiations, wasn't it?
Sorry, could you repeat the question?
The timetable was one of the other key demands of Royal Istana during the negotiations, wasn't it?
I wouldn't, it was probably likely that it was mentioned at some point during the negotiations, but I'm not sure if it was a key demand. Royal Istana seemed much more hung up on price, than anything else.
We hear you, Mr. Spector. If you turn to paragraph 3 of your witness statement.
Sure.
The last line says, you told Mr. Ross that you needed more information before making any firmer commitment about the timetable.
Yes, I see that.
So at the time you spoke in July, Mr. Ross had asked you to make a firm commitment to the timetable, didn't he?
You mean in July was like our first call, one of the first contacts I had with Mr. Ross, and he mentioned that they'd like to get it up and running between January 2017 thereabouts. And what I told him was that
sorry,
in theory that might be
Spector,
possible.
but that was not my question. My question was, did Mr. Ross ask you to make a firm commitment to the timetable?
I'm not sure if he phrased it as such, but in response to him wanting to have ideally having completion in January 2017 thereabouts, I just said that my response obviously could not be definitive at the stage, given that it was our first chat and we had little to no information at that point.
Understood. And if you turn to Exhibit A, I believe you have that in front of you on the second page.
Yep.
There's an email from Mr. Ross to you dated 18 October 2015.
Yes, I think that's the first one in the chain. Yes, got it.
The subject line of the email is timetable. Do you see that?
Yes.
And Mr. Ross is asking you in writing for a firm indication of when the project can be completed, correct?
Yes, I see that.
And in the second sentence, he says, I have asked you for this before. Do you see that?
Yeah.
And after that, he complains that you have not sent him that information. Clearly, it was important to Mr. Ross that you provide him with a firm indication on the timetable that he repeatedly asked from you. Would you not agree?
He certainly was pressing for it in that email.
And when you and Mr. Talor spoke about Royal Istana's timing requirements, he mentioned to you that Nucleus Energy could divert a plant or components from plants from other projects to the Iraq project. Isn't that correct?
Sorry, when I and Mr. Ross or Mr.
Talor.
Yes. Yeah, we were aware that we had a project that we had some spare parts for.
And you told Royal Istana that you had these spare parts and that it might reduce the time needed for the project by several months, didn't you?
Yes, we mentioned that it's possible to use spare parts to reduce the time.
And if you look at paragraph 7 of your witness statement,
yeah,
you specifically mentioned to Mr. Ross that there was a project in Indonesia that had stalled, and the parts for those projects were sitting in storage in Texas, correct?
Yeah. Yes, I do mention that.
And you told Mr. Ross during negotiations that using those parts would speed up the timetable considerably, didn't you?
I think it's standard industry practice that obviously using prefabricated parts would be faster than building from ground up. That's why I conveyed to him.
Yeah. So you did convey that to him?
Yes.
In the last line, if you go back to Exhibit A with me.
Yes, sure.
Do you see the bottom of the first page is an email from you to Mr. Ross on the 18th of October? And you are replying here to Mr. Ross's request for a firm indication on the timetable, correct?
Yes.
And you see the first line that says, it goes without saying that using the diverted plant components will speed things up considerably.
Yes.
And you say here, I think we will be able to meet your demands, correct?
Yeah, in the email, I did mention that obviously we can't be definitive, given that there's no contract, no program, we haven't seen the designs, but we were more confident about moving things quickly, given that we had some spare parts in our inventory. But of course, no definitive commitment.
I'm mindful of the time, and then just a last question for you, Mr. Spector. Would you agree that the demands you were referring to here that you would be able to meet were demands regarding the timetable?
Yes, it will be demands with regards to how fast we can progress the project.
Mr. Ross, I would love to ask you more questions, but unfortunately, I think our time is up today.
Thank you.
Thank you so much.
Yes.
Thank you so much, sorry, Blossom. Thank you so much to the speakers for the two very exciting as well as entertaining cross-examination sessions. We will now proceed to start the panel discussion on how to conduct a successful cross-examination. Let us hear first from the tribunal. I will first like to invite Blossom. I'll start with you. Could you share with us how do you think is to successfully do a cross-examination? And if you have any comments on earlier sessions, please share with us too.
Sure. It's a pretty big question on how to conduct a successful cross-examination. So I'm just going to focus on a tiny bit of it. The main point really is to have a conversation with your witness. Listen to what your witness is saying. Don't be slavish to your script. I think from the session that we had, one of the issues was we had a couple of quite evasive and volunteering witnesses. They want to give you all the information out there but not answer your question. One way of dealing with that is to ask the same question again in exactly the same words, in exactly the same tone, to slow it down. You're not repeating yourself because the witness has not answered the question. So you are actually just emphasizing to the tribunal so that the tribunal will then conclude for itself that the witness is not answering the question. So for example, the question can be, so you stabbed him. And the guy says, you know, we were really good friends, grew up together, you know, I've known him since I was 7, we went fishing, then you. And this is something the judge has shared with me. You do this. I mean, it's more difficult virtually, but putting out your hand in front of him stops anybody, right? So you stabbed him. You know, everything happened so fast, I just can't say, so you stabbed him. And you know, by the 3rd or 4th time, the guy is gonna say, yes, I stabbed him. And even if he doesn't, I think the tribunal will conclude, yes, he stabbed him. So that is one way of dealing with an evasive or a volunteering witness. And I just wanted to share that.
Thank you so much, Blossom, for sharing that with us. Moving on to Darius, could we hear from you? And maybe, is there any favorite techniques of cross-examination for yourself?
Yes, sure. So most of the audience would be aware of the basics, keeping the questions short, using predominantly leading questions, etc. But going beyond the theory, in the limited time that I have, I thought I would share 2 techniques that I had to learn the hard way over the years. I'll share what they are, who I learned these techniques from, and hopefully these techniques might resonate with you. The first technique is what I call storytelling. And this is a technique that I picked up from Constantine Partasides. And he shared that cross-ex is not about dueling with the witness. It's about storytelling with the arbitrator as the audience. So in modern arbitration, where most witnesses will have been prepared, will have gone for some kind of familiarization training, it will be rare, as you can see from today's session, where you'll be able to extract any kind of admissions from a witness. So instead of getting frustrated and flustered, and none of our counsel here today got flustered or frustrated, you shift the focus away from the witness to the arbitrator. You prepare the factual story that your side wants to tell, and you break it down into concise statements. You tell that story using the form of short leading questions, one at a time. So when the arbitrator sees the story unfolding in tandem with the documentary evidence, that will remain etched in their memory, whereas the witness repeated resistance will tend to fade in comparison over time. The second technique I would like to share is the use of cross-ex bundles. And this technique was shared with me by Mr. Michael Huang. Now, compared to TV shows where cross-examinations are slick and fast-paced, modern arbitrations are not like that, okay? You must agree with me that nothing is more tedious than everyone turning around every few minutes to retrieve a bundle, whether physical or electronic, looking at the cover to make sure it's the right volume, and turning to the right tab, and then locating that particular document which the cross-examiner wants to refer to on cross. Having a cross-ex bundle, I find, having a cross-ex bundle prepared beforehand, comprising all the documents in the record that would be relevant to your line of questioning, helps in 2 ways. First, by maintaining your momentum and the flow of your questions, your story tends to stick better in the memory of an arbitrator, okay? The second benefit is a psychological one. It speaks volumes to everyone in the room about your preparation and your confidence in your case when you hand over a cross-ex bundle before the cross-ex begins. I'm just going to pause there and let the other panelists chime in.
Thank you so much. Is there any other panelists who would like to chime in following what Darius has said? Okay, while we're waiting, I will now move to Yutaro. I understand that Yutaro is practicing in Japan, which is a civil law jurisdiction. I think many would be eager to hear how cross-examination is perceived in a civil law jurisdiction, and how do you think it would take to conduct a successful cross-examination?
Right. You know, you might be hating me for not addressing that in a straightforward way, but Japan is a civil law, although it's a civil law jurisdiction, we do have intensive cross-examination before the court. So the tip topics and the tips that been already rendered by my colleagues, Blossom and Darius, would apply for cross-examinations in a civil law jurisdictions as well. And I think civil law practitioners that haven't really done cross-examination should be versed with the techniques as well. And these sort of exercises would help us in understanding how to do it. I just wanted to add a few observations, if I may. I'll keep this short, maybe a minute,
Sure.
of what I felt having experienced in sitting here for the past hour or so, just as an arbitrator, and some observations that I have. I think I've done video conference, video hearings before, but that was with the liberty of the 70-inch screens in my office conference room, and with but now I only have my iPad Pro in front of me, and it's very difficult with this Zoom exercise. You just keep on shifting from your speaker view and your gallery view without really trying to figure out which is the best. That's one observation. Other, I think I'm not going to go down my full list, but one other thing is that it's really probably hard for the tribunal to intervene, and it was really probably hard for counsel to make objections and intervene as well. I felt that that might have been the case for Ramesh and Vijay as well. On top of that, just two things. It's just that if you have the gallery view, there's much distraction here. You're looking at other people's screens. I have Blossom nodding. You're looking at your fellow arbitrators' faces while you should be looking at Sharon's faces, and then the witness face pops up, and it just keeps on shifting and shifting. So that's one of the hardships that I found right now. The last thing that I want to finish is that I'm in my jacket and my shorts, and my shirt, but actually underneath me, I'm wearing only a short. I just did this not as a joke, but I just thought that this might be a real life experience for me to try it out. I don't recommend it. It's just that it makes you feel a little bit unprofessional, and you kind of lose concentration along the side if you do this. So I know that nobody would want to see my naked legs, but I just wanted to say that don't do this. And this is my experience. I'm just going to pass it to the rest for the comments that we have, and looking forward to hearing them. Thank you.
Thank you so much, Yutaro. All right, after hearing from the tribunal, I will then move to Eddie, who I understand that has been cross-examined in person before. So Eddie, could you share with us how was your experience being cross-examined virtually for the first time?
Thanks, Joanne. Yes, it's been a really interesting experience. I mean, for me, it's the first time that I've been cross-examined in a virtual setting. I mean, in the past, my experience as an expert witness has always been in an in-person hearing. I think in a number of ways, the experience is very similar. You know, as the questions began to flow, I found myself being drawn into the cross-examination and sort of quickly forgot that, you know, we're in sort of different physical locations. So from that perspective, it felt very real. I also kind of like having the documents on the screen next to me to cross-refer to. In some ways, this could have an advantage over paper documents. So, for example, if you need to walk through a complex valuation or lost profits spreadsheet model, you can do that, I think, more easily on screen rather than in a physical copy. I mean, that said, I think there are some differences. When you are being cross-examined as an expert witness, you're responding as much to the tribunal as you are to the person cross-examining you. You're kind of scanning the room for the tribunal for non-verbal clues to make sure that they're kind of following what you're saying, understand the points you're trying to make. As I think Yutaro sort of mentioned, I found it much more difficult to read the body language of the arbitrators, in part because they're split across my screen in sort of 3 separate boxes. I found myself scanning sort of much more intensely at the screen than I would physically do in a physical hearing, which is it's much more natural. So I think for short sort of 10-minute cross-examination, this is fine, but for longer cross-examination, it might, you know, it might be a bit more taxing for the witness and probably for the tribunal as well. So maybe 1 or 2 extra breaks would be helpful in this regard.
Thank you so much, Eddie. Okay, now I would then like to ask counsel generally, say, what was your experience like cross-examining a witness virtually? I'm not sure whether you have done this in a real hearing, but now in this mock hearing, can I hear maybe say start with Lomesh?
Sure, thank you so much. Yeah, I mean, this is the first time I cross-examined in a virtual world as well. The experience is obviously very different from cross-examining in person. One of the points is, as the other panelists also mentioned, is to really gauge and sense the body language from the arbitrators. I think that's very, very important. And in a virtual world, somehow, sometimes you don't really know if the arbitrators are also following your line of cross-examination, because obviously the counsels have come with a particular strategy and we're trying to come to a particular goal. So I think those elements of really understanding and getting a sense of what the arbitrators are actually feeling, that is lost. Secondly, I think obviously this is an issue that would arise in a virtual world as well. And this is where you'll need really good technology platforms, is to really ensure that the witness is not in a position to take any kind of help or assistance, either from a technology source which is around him, some scripted answers around him, etc. So it's very important that the integrity of cross-examination is maintained by ensuring that whichever platform we get onto sort of addresses those issues. I do understand that there are already certain platforms in the market that addresses that. But overall, I can say that it's been a good experience in that sense. It's a very different experience, but the basic fundamentals of cross-examination would still be the same, whether it's a virtual world or whether it is in person.
Thank you, Lomesh. Moving on to Lijin, do you have any thoughts about how was your experience like?
So the virtual constraints, I mean, there's the lagginess, and that creates a bit of tension and stress. And it's so easy to get distracted by it. And you also have to, I mean, at least for myself, tailor the delivery to this particular medium that we're dealing with. I find that in particular, it's important to have the questions even shorter, because you don't really have the luxury of an in-person communication. Of course, in this case, Benson didn't exactly make things easy. And although that said, I mean, I'm very thankful for all the speakers agreeing to join us on this session, and the people who agreed to play witnesses as well. I think there's a particular artificial constraint in this case, which is time, in that I think certain points would require time by in itself, especially when you have a difficult witness to deal with, to get them to the point where they have to make certain concessions. But that's something that we don't exactly have. And on the side of the witnesses, because it's an artificial problem as well, and as you can see, there are certain, I suppose you could call it in a way, Easter eggs are embedded within the problem that counsel would then be able to make use of, which, I think for the witnesses, it's something which is quite difficult for them to get around at times.
Thank you, Lijin, for sharing. And what about Jonathan? Do you have anything that you could share with us?
I echo everything that's been said before. I might just add a point about document handling, which I think picks up on something Darius had said. I think a cross bundle obviously is very effective, but I do wonder how one uses that in the virtual context. And you could see, I think, even in my presentation, that as Gerald was referring to documents, he was distracted and you couldn't really see him. And even if Eddie were to share a spreadsheet that all of us can look at, if we're all looking at the spreadsheet, then we can only look at one person's face in the small little box in Zoom. And so that, I think, creates new constraints in terms of how we handle documents. And I don't know if there's a technological solution, but I think that is quite challenging. And that would be my only observation.
Thank you, Jonathan. Last but not least, Sharon, what about your own experience?
Well, I think this has certainly been a very interesting experience, conducting cross-examination virtually. I echo everything that my co-panelists have said. And I think it is true. We have been quite constrained by time, and I think in a real life arbitration case, we would not probably have that problem. Coming back, I think on the document production as well. I don't know whether there is a platform out there where you are able to all get in sync into a separate virtual room where you could then, scroll through documents as you're going along. It would be quite different from a share screen feature, but there may be something out there. I think I've heard of something similar, but I'm not quite sure what it is called.
Okay. All right. Thank you, Sharon. I think Dimitris would like to share as well as to what about the difference between cross-examining in an in-person hearing as well as a virtual hearing.
Yes, I can be, so just a quick point, and thank you for the, what I thought was as a witness, in my lowly opinion, was a pretty good mock. I thought, but putting my hat of counsel on, one thing that seems to be quite different between virtual and real world is the ability to rely on your colleagues in real time, especially in a cross-examination in the sort of COVID context where you're in lockdown and all alone. Because generally in a real hearing room, especially if you're senior counsel, you will certainly be relying on somebody to give you documents, to sometimes point you in the right direction, or to say, no, that's not what he said in some other document. So I think that will probably get lost a little in the virtual context.
All right. Thank you so much, Dimitris. All right, we have a question from one of the attendees. So the question is, can the authenticity of any of the exhibit be questioned during cross-examination in an arbitration? Would we have someone to answer this? The tribunal, perhaps? Maybe. I'll repeat the question.
I can take.
Yeah, sorry, Ramesh, Lamesh,
Yeah,
sorry,
sure.
please go ahead.
Yeah, so the authenticity of a document can obviously be challenged in cross-examination. I mean, that's a line of questioning you can always take. You can discredit the, credibility of a witness in terms of the kind of documentation that has been produced. That is always open to a party. Of course, the contract in this particular dispute is based on the UAE law, but I would presume that under most common law jurisdictions, under the laws of evidence, you can always take a challenge and a line of questioning just to question the authenticity and the admissibility of the document itself.
Right. Thank you so much, Lamesh. So basically, earlier during the first cross-examination for the claimant's witnesses, Mr. Harvey Specter had experienced some sort of technical issue. Then I think maybe Gerald can let us know from his point of view, how was that like, the experience, and what do you think we could, for future cross-examination, could be done to maybe prevent similar incidents?
Thank you. Yeah, so obviously that was all planned, or not. But I think it's important, for the tribunal and counsel to be flexible as they were in this case, being able to move to a different witness or proceed with another aspect of the hearing, while sorting out connection issues or technical problems, especially if those problems last for a more protracted period. And I think these things should be discussed or thought of beforehand. I think one big difference, with the virtual hearing is that in terms of hearing preparation or the PO before the hearing, there are now many more aspects that have to be considered. I think various institutions and bodies have been trying to come up with protocols, be it from a technical aspect, logistical bundles, chat rooms, what is permitted, what's not permitted, access, whether one witness can hear another witness's testimony. All these have to be set up in a virtual context, and even cybersecurity, data protection. So it gives a lot more to think about, and might even be much more work, in fact, to set up a virtual hearing. Thanks, Duane.
Thank you so much, Gerald. So this question is open to all panels. If you would like to answer this question, please let us know. So what do you think the future of the online ODR, especially arbitration, according to the panelists in the post-COVID world? So how do you think the future arbitration would be like post-COVID, given that now there is so much online virtual hearing that's going on? Do you think that would maybe be a new norm in the future, or would people still prefer to go back to in-person hearings?
So if I could just step in here with your permission. There were a
Sure.
couple of comments which were raised earlier about, the fact that if it's a virtual world, you may not be in a position to sort of get the counsel of, the junior counselors assisting you, or to have a private kind of an interaction between the parties. I must say that there are products in the market today which have been launched, which are quite remarkable, because what it does is, while you're on that particular platform, the respondent counsels can separately have a chat room which cannot be seen by the other parties, and a separate discussion can take place there. And you also have an option of checking the documents separately. So those innovations, I mean, Jonathan and few others had mentioned that these could be certain challenges, but I can certainly say that these challenges have been addressed in some of the newer technology platforms that have come. And to answer your question, I do believe that technology is the way forward, especially in arbitrations. I do understand that there would be significant challenges insofar as the court process is concerned, but insofar as arbitration is concerned, I do believe that there are tools to address all the issues.
Thank you so much, Lomesh. All right. Fortunately, our time is up today. Thank you very much to all the speakers today for your valuable opinion and contributions. And thank you for all of you that has tuned in today to support our YSIAC webinar. Please remember to fill in the feedback forms after this webinar, and we'll see you in the next webinar. Thank you so much, everyone. Have a good evening.
Thank you.
Yeah. Thank you. Bye.
Thank you.